So welcome, everybody. Good afternoon. This is our first regular meeting of the Climate Emergency Mobilization Commission for the City of Los Angeles. Today is Tuesday, June 28th. My name is Marta Segura. I am the Executive Director of the Climate Emergency Mobilization Commission. Today is the launch of our first meeting, and I want to thank you all for agreeing to serve for this one-of-a-kind commission. Today, we will focus on the orientation of our commissioners, and we hope that you find it useful. So I will call this meeting to order. That being said, the next step is roll call. We need to establish roll call and quorum for today's meeting. We will first confirm that we have quorum. Once we have confirmed, then we can move forward. So I'll call each one by name. We will track. You don't have to do anything. We know who's here. Commissioner Badejo, Commissioner Directo, Commissioner Duarte, Commissioner Ferguson, Commissioner Fritz Armenta, Commissioner Gutierrez, Commissioner Johnston, Commissioner Michael Martinez, Commissioner Madoff, Commissioner Mejia, Commissioner Monge, Commissioner Ortega Jr., Commissioner Padilla, Commissioner Zalin, Commissioner Luis Angel Martinez. Let me check real quick to see how we're doing with quorum. Michelle, can you confirm quorum? I can't hear.
So we have a quorum, Executive Director. We have a quorum.
What is the total?
Total is 13.
Thank you. Okay. All right. Congratulations. We have quorum for today, and we can move forward with meeting. For today's meeting, we have quorum with a total of 13 people. There are 16 people appointed, and a few of you let us know in advance that you couldn't make it today. For the first item on today's agenda, we have the Executive Director's brief report. I wanted to let you all know that today we'll be taking one action to approve AB 361 to allow the commissioners to continue to meet virtually during this pandemic period, and the city attorney will review that more briefly, more thoroughly. We will take votes in the future, but those votes will take place at a future meeting after today's orientation. We will also review the guidebook and the blueprint, in which you'll find the ordinance, you'll find the calendar of all of the meetings that we will be attending. You'll find the draft administrative rules that you will be considering for your next meeting in order to take formal action and adopt them. So you'll have a time to review and preview before you take action on the draft administrative rules. We will also vote on presidents and 2 vice presidents at the next meeting. So you'll have time to consider whether you'd like to nominate someone. And then we'll review the agenda for today. Time permitting, we'll take questions at the end. And also, if we didn't get to your question, then you can let me know or directly connect with the city attorney. So the main topics that will be covered in today's orientation will be the Brown Act, the Public Records Act, and Ethics and Commissioners. You should have received those materials confidentially from our office, separately from the guidebook. I want to thank all of the city attorneys that are with us today, including Steve Martin, Lindsay Zwicker, and Renee Stadel. But before we go there, I'd like to turn it over to general public comment, which is the next item on our agenda. Do we have any callers in the queue for general public comment?
Executive Director Segura, at this time, we do not have any callers on the line for general public comment for today's meeting.
Great. If no, then we can continue. Thank you for that information. And with that, we can officially close the general comment period. So moving over to our next agenda item, the city attorney will deliver an orientation presentation regarding the commissioners and the topics I discussed, ethics, Brown Act, and the Public Records Act. And we'll also go review the requirements and responsibilities pursuant to Assembly Bill 361. So with that, I'll turn it over to City Attorney Steve Martin.
Thank you, Director Segura. Can you please confirm you can hear me okay? I had to switch computers here.
Yes, we can hear you fine.
All right, and our missing commissioner maybe was having similar technical difficulties. I wasn't able to pull it up on a Galaxy phone that I had, so I had to switch over to my computer for this.
Oh, that's possible.
So I just want to say thank you to everyone for showing up and welcome. It's a pleasure to meet you all, new commissioners. My name is Stephen Martin. I'm a deputy city attorney. I focus on environmental law in the city attorney's office. And my colleague, Lindsay Zwicker, and I are designated as the commission's general counsel. So we're here to serve in the role of answering your legal questions that arise as commissioners. Renee Stadel is also presenting today. She's an assistant city attorney, and she's most graciously helping us with presenting on a complex topic of government ethics, which is something that's very important that you all should be aware of as commissioners. But before we get to their presentations, I want to give you some background on the commission, where it came from, what it does, so you can better understand your role as commissioners and as together as a commission. City Council created the Climate Emergency Mobilization Commission and the Climate Emergency Mobilization Office together by ordinance last year in June of 2021. I'm hopeful that you've all received a copy of the ordinance. It should have been sent to you. So if you have that, that's a great document to just take a read through and try to familiarize yourself, if you haven't already, about what the roles are of the commission relative to the Climate Emergency Mobilization Office. If you don't have a copy of it, it's available on the city clerk's website, or I'm sure Director Segura can provide you with a copy if you don't have it readily available to you. Looking at the ordinance, the first 6 pages or so are about the commission. The pages 6 to 8 deal with the Climate Emergency Mobilization Office. Now, with respect to the commission, over the last year, the city's been finding and appointing all you all to fill the commission's 19 seats. Typically, commissions are appointed by the mayor, and they manage and advise or work through a department. Here, however, the commission isn't fully appointed by the mayor. Two are appointed by council members, one by the council president, one by the chair of the Energy, Climate Change, Environmental Justice, and River Committee of the City Council. And the 17 remaining members are appointed by the mayor with various qualifications and backgrounds, representatives from indigenous tribes, Cal EnviroScreen scored areas, youth representatives, folks having backgrounds in labor or climate change, air quality, toxics, or workforce. Those are the qualifications of those particular members. And so because of this structure of the commission, which was specified by council and guided by charter requirements, this commission is somewhat different compared to mayor appointed commissions. Technically, it's more of a committee because of its advisory nature. Its role is to advise the mayor and the city council. It does not advise nor manage a city department or appointed offices. So this gets to what I suspect is your biggest questions as commissioner, which is how do you as a commission take actions to contribute to the city's climate change activities? That's what you're here to do. So as I noted, the commission does not manage or advise a department. So the commission does not manage the Climate Emergency Mobilization Office. The commission does not otherwise send direction or advice to the Climate Emergency Mobilization Office. if you look at the ordinance, you'll see that it provides that CEMO, the Climate Emergency Office, and CEMC, the commission, are two distinct bodies. And so CEMO, the office, is established within the Department of Public Works. So CEMO answers to the Board of Public Works, which is a separate sister commission to this commission. And so that's how it creates this distinction between the Climate Emergency Mobilization Office and the commission, because they're separated. There's a different power structure as far as CEMO's responsibilities to the Board of Public Works. So the way that this commission takes action isn't by sending reports to a department to act like it would if it was sending them to the Climate Emergency Mobilization, but instead it sends the reports upward to the mayor, to the council, for action by the council and the mayor to effectuate something, whatever actions are being taken. And that would most likely be through a report prepared and submitted by Marta Segura, acting as the commission's executive director, to send that report up to the mayor and council for their action. But even though they're distinct, you can see that the Climate Emergency Mobilization Commission and the Climate Emergency Mobilization Office are somewhat related because they have a common subject matter. Marta Segura automatically serves as the executive director for this commission because she is director for the Climate Emergency Mobilization Office. So she wears two separate hats in that role, but that somewhat connects the two. Also, if you look at the Climate Emergency Mobilization Office's duties, it includes responding to direction responding to direction and advice from the mayor and the city council related to the subject matter of the commission. So if the commission sends reports up to council and the mayor can then take action and return the flow of information back to the Climate Emergency Mobilization Office. And you also see that the Climate Emergency Mobilization Office's duties include submitting reports back to this commission related to the commission subject matter. So the basic gist of this arrangement is that the commission will typically receive and deliberate on reports that are coming from the office, the Climate Emergency Mobilization Office in the Department of Public Works, and then prepare reports on its recommendations and submit them up to council for policy guidance on an action and for council to take the action on that guidance. And so then council would take advice and consider taking direction and it would work its way back to either the Climate Emergency Mobilization Office or perhaps somewhere else in the city as far as taking other policy directions that city council would want to take based on the action that's advised from this commission. So I think that's where I'll leave my presentation at this point. Hopefully it gives you the big picture about how information flows around the commission and how change can be affected by this commission and what its role is. The specific duties of the commission are all related to climate emergency. They're spelled out in the ordinance. And I believe that Executive Director Segura has provided a brochure that kind of explains and actually just lists those responsibilities that are stated in the ordinance, but it involves advising city council and the mayor on various policy topics of climate emergency, toxic pollution, biodiversity, environmental justice, health, job creation, equitable and meaningful involvement, building capacity in disproportionately burdened communities. I'm sure we'll explore those in more detail as we start working through some particular matters as they arise in the commission's consideration. So that's the end of my presentation. I'll turn things over to Renee Stottle, who will now give a presentation on some of the ethics concerns that you may also be concerned about.
Thank you, Steve. Welcome, everyone. Thank you for your service to the city. And I'm going to talk to you a bit about ethics and conflicts of interest and try to divine for you which laws apply to you and how to recognize issues so you can ask us questions about whether you need to recuse yourself. So Rebecca, if you could move to the next slide. I think there's a slide before that. Well,
Bear with me for a moment. I'll fix that.
okay.
Thanks for your patience. That's what I have.
Okay, well, I'm going to talk a little bit before this slide. There are a number of laws that generally apply to public officials. And if you've ever been on a commission or an employee of the government in California, you may be familiar with them. But I just want to go over them to give you a flavor of which laws you're subject to and which ones you're not. So the main conflict of interest law in California is the Political Reform Act. And it governs a lot of things: conflicts of interests, gifts, campaign finance, lobbying. But because you are strictly advisory, you are not going to be subject to the provisions of the Political Reform Act. Another law is the city's governmental ethics ordinance. And again, because you're strictly advisory and won't be completing Form 700, which is a financial disclosure document that a lot of city officials have to file with the Ethics Commission, it's not going to apply to you. So what does apply to you? If my understanding is, as a general matter, you may not be making recommendations on contracts, but I understand there's a possibility that you might be you might be called upon to make a recommendation on a grant, which is considered a contract. So that law will apply to you, and I'm going to talk to you about that to give you a flavor of that. And also, there's a common law doctrine of conflicts of interest, and I'm going to talk to you about that. So next slide, please. So just as a general matter, conflicts of interest means that you're not going to participate in your official capacity as a commission member on matters that may impact your private interests or appear to impact your private interests. That means not only not voting on an item, but not attempting to influence the decision by talking to other commissioners or other staff about the item. Generally, a conflict of interest doesn't only mean voting on something where it's going to benefit you, but also can be a situation where the item that you were asked to vote on or consider will have a negative impact on your interests. So as a general rule, whenever there's something that is coming before you as a commissioner, and you have some personal interest in the matter through relationships or other, and I'll talk about that in a little bit, you need to keep those two things separate. They shouldn't overlap. So next slide. So the common law doctrine of conflicts of interest is in part based on case law. And in 1928, there was a case called Noble versus City of Palo Alto, which described what it meant, that a public officer is impliedly bound to exercise the powers conferred on him with disinterested skill, zeal, and diligence, and primarily for the benefit of the public. So again, it's a situation where serving on a commission or serving in government means you're there to serve either the governmental entity or the public, but not your personal interests. The common law doctrine applies to both financial interest and non-financial personal interest. And if you have a conflict under this doctrine, that means you should be disqualified from taking part in any discussion or vote on the matter. Next slide. Some examples of interests that might count as under the common law doctrine where you should recuse yourself are financial interests. It could be a number of things. Commonly, sources of income, your employers, your clients, people who give you big gifts, tenants, things that impact your real property, investments, or personal finances. Sometimes serving on the board of an organization can create a conflict if they have a specific matter that's going to impact them. Or if you're close family members, your spouse, your children, siblings, if they have matters specifically involved in matters before the commission, that can raise a conflict of interest as well under this doctrine. So next slide. So I thought it would be good at this point to touch base about what does it mean to recuse yourself. Recusing means not participating in the decision at all, not voting, not discussing it, not talking to the commission staff about it. There should be a couple more points on this slide. When you are recusing yourself, you should state on the record of the meeting why you are recusing. You are not required. The city's commissioners under the city's ethics ordinance, which you are not subject to, have to fill out a form and file it with the ethics commission. You are not required or subject to do that. But again, we strongly recommend that you state any recusal on the record. If you don't know, if there's a matter coming up and you don't know whether you should recuse yourself, we recommend that you contact our office, Steve or Lindsay, for advice about whether you should do so. When time is short and there might be a number of considerations to think through before deciding whether recusal is actually necessary. We always recommend to err on the side of recusal if the situation is not clear, because that's the safest course of action, both for you and for the city. Thank you. Next slide. So the next item that I was going to talk about is Government Code Section 1090. And it's a state statute that generally prohibits public officers from being financially interested in contracts made by them or by the boards in their official capacity. It applies to city officials and employees. It can also apply to advisory board members and consultants. Next slide. So the provision means that a public officer or employee cannot participate in any way at any stage of the approval of a contract. Any participation in which the contract is developed, negotiated, or executed, execution might be an apt phrase for what happens if you violate the law, not actually, but figuratively, is a violation of law. Next slide. So as I mentioned, it's a broad statute, and the terms have been interpreted by the Attorney General in case law over a number of years. Making a contract, participating in contract matter means not only voting on a final contract to approve it, but it includes advising on it, seeking to influence it, recommending it, negotiating it. It can also mean making a recommendation for the contract, and contract doesn't just mean, you know, it's a contract with a particular person. It is also at the stage of, if you were to be involved of an RFP process. Financial interest under this statute is broad, and it also extends to your spouse. Next slide. The case law talks about how broad the statute is to avoid perceived conflicts of interest. No matter how twisting and winding the trail may be, if the connection between the financial interest of the official and the contract can be made, a violation of section 1090 will be found. Next slide. So this slide has some examples of what has been considered to be a financial interest under section 1090. And it's frequently in the context of the types of relationships that you have with someone else that is involved with the contract. Being an attorney for the party to the contract, an attorney, agent, or broker, a supplier of goods or services to the contracting party. In other words, they're your client or customer. Being a landlord or tenant of a contracting party, as I mentioned, being on a board or an employee of a nonprofit that is a contracting party. And a source of gifts can also be an issue depending on timing. Other interests count as financial interest under the statute. Again, if something would impact your real estate contract, that would be an issue. Certain investments, not public, not stocks, count here. And anything that might impact your personal finances. Next. So the statute is very strict, and I was going to mention, because you're an advisory agency, the way it applies is different than regular boards and commissions. If you have a financial interest on a contract matter, it only means that you need to recuse yourself. With regular commissions, sometimes the entire board is disqualified. But violation of the statute can be severe. It means that the contract is void, and a public official may be prosecuted for a felony and barred from holding public office in California. So it's a very serious statute. Next slide. And the LPPC can also impose administrative penalties. The Fair Political Practices Commission is the agency that also enforces the Political Reform Act. Thank you. Next slide. Here's a few examples of issues under Government Code Section 1090. We have had a couple of commissioners who were convicted of this provision and actually went to jail. One example is a commissioner was a consultant for a company and then voted on contracts with the company. Another example was a commissioner who had loaned money to a corporation and then voted on a lease with that corporation. Another example is not here. A city council member voted to create a loan program, and after leaving city council, applied for a loan. Well, that's also prohibited under the statute. Next slide. I just was going to mention very briefly, there are also criminal laws that can apply if you are engaged in criminal activity, basically quid pro quo activity, bribery and honest services fraud. You may have seen in the paper yesterday There was a developer that was convicted of bribery and honest services fraud for matters relating to the city. So next slide. So in sum, we recommend that if you have questions that you contact our office for advice anytime that there's a matter and before your commission that might impact your business, real property, a person with whom you have a relationship, negotiating future employment, or that would impact your personal finances. That doesn't, this list doesn't mean that you always will need to recuse yourself. It just highlights the areas where there's an issue and where you should ask. So that's my my presentation, and I thank you for listening.
Hello, everyone. I think we go to Lindsay Zwicker next on Public Records Act.
Hello, everyone. Apologies for, let me just get this started here. Okay. All right. Okay. So welcome, everybody. It's great to meet everybody, and I look forward to working with you. My name is Lindsay Zwicker, and I, along with Steve Martin, am General Counsel for the Commission. And we'll just delve right in. And I know many of you have gotten kind of more detailed kind of fact sheets / memos on the Brown Act and the California Public Records Act. So what I'm going to be presenting here today is just going to be kind of a distilled version of those fact sheets, just to kind of highlight the most important things and issues that I think are most relevant to you. But please do, if you haven't yet, peruse those documents and follow up with our office if you have any questions. Okay. All right. So the purpose of the Brown Act. It's codified in Government Code Section 54-950. And in enacting the Brown Act, the legislature finds and declares that the public commissions, boards, and councils and other public agencies in the state exist to aid in the conduct of the people's business. It is the intent of the law that their actions be taken openly and that their deliberations be conducted openly. And you know, essentially the purpose of the Brown Act is to ensure that the public, that the public can both access the government and monitor the government's actions and to participate in a meaningful way. And in service of this goal, meetings among commissioners or among boards or any legislative body must be open to the public, held on a regular schedule, and follow a noticed agenda. So essentially no secret votes, full transparency. What is a legislative body? The Brown Act applies to meetings of legislative bodies of local agencies. That includes governing bodies or subsidiary bodies, such as any board, commission, committee, or any other body of a local agency created by charter, ordinance, resolution, or formal action of another legislative body. As you know, the CEMC was created by formal action by City Council, and under this definition of the Brown Act, the CEMC is a legislative body subject to the requirements of the Brown Act. What is not a legislative body? Any ad hoc or unofficial advisory committee that constitute less of a quorum of a legislative body. Hopefully you are all aware that a quorum means a majority or greater than 50% of members of a body. So in the case of CEMC, since there will ultimately be 19 spaces for members. A quorum constitutes 10 members. Any unofficial advisory group to a single decision maker not created by charter or legislative action, or any other advisory group appointed by staff, and again, not created by charter or legislative action. So what is defined as a meeting? So a meeting under the Brown Act is any congregation of a majority or a quorum of the members of a legislative body that essentially have any sort of meeting of the minds. It could refer to an actual physical meeting. That's kind of the more traditional definition of or example of a meeting in non-COVID times. Where in order to hear, discuss, or deliberate any issue that is within the agency's business or within the agency's jurisdiction. This does include uses of technology, so an email or a phone conversation or now video conference, if it constitutes or if there is participation by a majority of the commission of the members, or the majority of commission members to discuss an issue that is relevant to the agency's business, then that is a meeting and it is subject to the requirements of the Brown Act and must be made public and accessible to the public. In order to get started and in order to stay in business, a meeting must have a quorum. So as soon as enough members leave a meeting such that there's less than a quorum, then the meeting must immediately adjourn. And generally, meetings are prohibited unless they are open and public, which means they are properly agendized, posted, and open to the public to attend and offer public comment. And we'll get into what that means, what it means to be properly agendized and posted and attended. And so when does that Brown Act not apply? So obviously, you know, if there just happens to be 10 plus members of the commission attending a retirement party or any other sort of social events, you know, no, that doesn't automatically trigger the Brown Act and mean that you have to make your conversations available to or open to the public. However, you do have to be careful that when you are conferring with other members of the commission, that you are not discussing agency business unless it is within the context of a properly agendized noticed meeting. So, you know, there's nothing prohibiting you from attending and participating in other community meetings and other public meetings, such as city council meetings or planning commission meetings. Again, just as long as you're not discussing your own agency or your own commission's business with other members of the commission. So other kinds of meetings, what's called serial meetings, and this is something that's particularly relevant in this COVID and, you know, online era. Different kinds of meetings, the different kinds of communications that would qualify as a meeting under the Brown Act are what's called hub and spoke meetings. So for example, if a staff member, so for example, Director Segura, if she briefs one commission member prior to a formal meeting on an issue related to agency business and reveals information about other members' opinions or their positions on a certain issue that will appear on a future meeting or has appeared on past meeting, that would be a violation of the Brown Act. You know, of course, staff members can communicate about relevant agency issues with commission members. They just have to be careful not to share other commissioner positions or opinions on that issue. A daisy chain communication or a daisy chain meeting. So it's kind of like if you imagine like a game of telephone, if member A contacts member B about a business matter, and then member B goes on to contact member C, and they're all discussing the same issues, member C contacts member D and so on, that would be a violation of the Brown Act, even though that meeting isn't happening, those communications aren't happening, you know, simultaneously. The fact that there is sort of like there is kind of this mass communication or meeting of the minds without being available to the public is what would violate the Brown Act. And then of course, email, be very careful that with commissioner emails, you're not replying all. You know, if you are going to send out a mass email, please BCC so that, you know, if a mass email goes out to all commissioners regarding a matter of agency business or of the commission's business, you know, that could be a violation of the Brown Act. So 3 main types of meetings, you know, most common are regular meetings. So they are the in our case, the monthly calendared meetings. And for those meetings, the agenda must be posted in a public space at least 72 hours before the meeting. For special meetings, those are called by either the chair or the majority of board members or commission members, and the agenda or the notice must be published 24 hours before the meeting. And board members must be notified, or commission members must be notified in writing. And emergency meetings, which are exceedingly rare and usually apply for like crisis situations, disasters, health and safety emergencies. Same notice requirements as for special meetings, but only 1 hour of notice is required. In terms of further notice and agenda requirements and public participation requirements, again, notice is required for all meetings. Generally speaking, the notice and agenda can be one and the same. Although agenda is only required for regular meetings, oftentimes an agenda is provided for special meetings as well. All meetings must be, well, we'll say, unless it's, all meetings must be open and public, and all persons must be permitted to attend. There is no secret voting. There's no condition placed on the public in order to attend. Also for in-person meetings, as well as for online or for video conference meetings, accommodations must be made for anyone with a disability. Every meeting space must be accessible and available to anyone. As far as the agenda goes, this must be posted in a location freely accessible to members of the public 24/7, again, so at least 72 hours in advance of a regular meeting. They must state the time and place of a meeting and provide a brief general description of each item of business that will be transacted or discussed, including the items to be discussed in any closed session. So any closed session, we'll discuss what happens during closed session in just a bit. But it should provide enough information so that people are able to decide whether they want to attend and participate and give public comment. And notices must be posted on the agency's website. And I think Steve touched on the website earlier. The Brown Act doesn't require the keeping of minutes. However, it does require a report on the actions that were taken in open session and each member's vote. Most agencies announce the vote taken and keep at least brief minutes, which include the content of the motion, the first, second of the motion, and the final vote on the motion. So when items arise that are not on the agenda. So unless an item that falls within the commission's jurisdiction is properly agendized, it can be addressed and discussed during public meetings as long as no action is taken, except when a majority or a quorum decides there is an emergency situation, or if 2/3 of the members present, or if there are less than 2/3 of all members present, then all members present at the meeting vote that immediate action is needed and the need came to the commission's attention after the agenda was posted. So after that 72-hour threshold. And when an item appears on the agenda and was continued from a meeting held not more than 5 days prior to that meeting. During general public comment, again, the public has the right to raise issues that fall within the agencies or within the commission's jurisdiction during the public comment period, even if it doesn't pertain to a specific issue on that agenda. And the commission may comment on those issues as long as it's a brief response to a statement or question during the public comment period. The commission or a commission member may refer staff in order to respond during the meeting. And they may request staff to report back and or direct that the item is placed on a future agenda so that action can be taken at a different date. And they may also briefly announce a report on an individual member's own activities. So in terms of the public's rights when attending or participating in a public meeting, the public may address the commission on matters of the agenda either before or during consideration of the item. Other matters that are within the commission's jurisdiction may be raised during regular meetings unless the commission allows otherwise. So, generally during the public comment period, that's where kind of any and all issues, whether or not they appear on the agenda that are relevant to the commission, may be raised by a member of the public. The commission cannot prohibit or restrict public criticism of the agency or of the commission. But of course, personal attacks don't need to be permitted. Those, can be reasonably restricted or censured. And the commission must provide reasonable time limitations and other regulations. And as Director Segura mentioned at the beginning of this meeting, you should see the draft board rules for the commission, which you will have the opportunity to review and take action on and potentially adopt at the next regular meeting. And those rules contain what will be potentially the commission's policies for time restrictions and other policies regarding public comments. So in terms of records and public access, so generally the meetings and the minutes, if there are any, and any handouts distributed at commission meetings are considered public record. Any documents pertaining to an agenda item must be made available to the public, and posting on the website is okay. And this includes any staff handouts distributed to the board or the commission less than 72 hours prior to the meeting. And any handouts provided by staff during a meeting must be made available to the public at the same time. And any handouts from the public must be made available after the meeting as well. So teleconference meetings during COVID-19. This was briefly raised earlier this meeting. So in September of 2021, the state adopted the state legislature passed AB 361, which temporarily dispenses with certain requirements under the Brown Act that would obligate the commission to have a physical meeting at a specific location, or have physical postings of agendas, or require a quorum of the membership to be within the jurisdiction of the city. These requirements have been temporarily suspended as long as the commission follows certain requirements. So, for AB 361, in order for the commission to continue to meet remotely, as long as, we're in a declared state of emergency due to COVID, then the commission must make certain findings that there is an ongoing public health crisis, and that that meeting remotely is a matter of public health and safety. As long as the commission can make those findings during a meeting, either a regular meeting or a special meeting, at least every 30 days, then it can continue to meet remotely. And you'll notice on the agenda, the findings prescribed by AB 361 do appear, and you will be taking action on those findings at the end of this meeting. And you'll also notice from, I think you should have the calendar of meetings available for the rest of the year. Although there are regular monthly meetings, some of those meetings fall outside that 30-day window. And for those times, for those kind of intervals, we've scheduled a special meeting for the express purpose of making these required findings under AB 361 so that the commission can continue to meet remotely. And this act will expire at, I believe, at the end of 2024. So hopefully by then we will no longer be in a state of emergency. So remedies for non-compliance. So the enforcement mechanisms in place for violations of the Brown Act. Civil action under, the topic of civil action, a district attorney or any interested person may ask a court to stop any violations, determine whether the Brown Act was applicable to certain actions or whether it has been violated, and to compel the board or the commission to tape record a closed session. A remedy for a violation, the most common one, is invalidation. So if any action was taken in violation of the Brown Act, then that action can be invalidated. However, the commission will generally first have an opportunity to cure that violation before any sort of sanctions would be imposed on the city. Okay, and so that brings us to the end of our Brown Act presentation. Again, you have a much more detailed fact sheet in the handout that was distributed to you. And hopefully you got a good sense of the kind of the overlying requirements and the basic intent of the Brown Act. And so now we will be moving on to the Public Records Act, the California Public Records Act. Okay. Bear with me. Okay. Okay. So, again, this, as you'll see, the California Public Records Act is of interest and concern to you as appointed officials and part of a governing body. However, generally speaking, it's most likely any request for public records will probably go through Director Segura, and as a matter of good practice, any Public Records Act requests that come the commission's way, the city attorney's office will be notified, and we'll work to respond to those requests. But generally, you should be aware of what the act says and what records would constitute public records under the CPRA. So the California Public Records Act, which is codified under Government Code sections 6250, the purpose is to give the public access to information that enables them to monitor the functioning of their government. So again, the goals are consistent with the goal, or similar to the goals of the Brown Act, just fostering public access to the workings of the government. And again, a similar tenet is enshrined in the California Constitution, which states the people have the right of access to information concerning the conduct of the people's business, and therefore the meetings of public bodies and the writings of public officials and agencies shall be open to public scrutiny. So, again, it's the right of the public to request public documents is considered a fundamental and necessary right of access. The public has a right to inspect documents, public records during local agency office hours, and they're allowed prompt availability of copies of public records. The CPRA applies to all state and local agencies. And in terms of what constitutes public records under the Public Records Act, it includes all writings containing information related to the conduct of the local agency's business, any existing, prepared, owned, used, or retained records by the local agency, even if those records or writings appear or were accessed from an employee or an official's personal device or account. So that means your personal emails or text messages, any personal devices could be subject to the Public Records Act if it concerns agency business. So be very careful when you are using your personal phones or your personal email accounts, because again, that could be subject to scrutiny. Writing is broadly defined and can include electronic information such as email, text messages, or even audio or video recordings. So the recording of this meeting will be public record and is subject to the CPRA. Again, some more, this is not an exhaustive list of public records, but just to give you an idea of what the scope of this of the act, or the definition under the act: papers, maps, drawings, books, exhibits, photographs, microforms, optical discs, CDs, DVDs, computerized data, voicemail, email, video, and audio tapes. And, you know, again, I'd like to state that this only applies to existing records. The agency or the city is under no obligation to create spreadsheets, or create or manipulate, or, you know, again, or anything, or obtain any documents that are not already in its possession and not already in existence. So the agency's duties when it receives a request for public records. The public agency must evaluate each request on its face to determine how to respond. It must balance the interests of the public in disclosure against competing interests of privacy, trade secrets, and then expectations of privacy issues. And generally speaking, the motive of the requester is irrelevant. It's a right. If somebody makes a request, it doesn't matter what they plan to do with that information. When receiving a request, time is of the essence. The agency has up to 10 calendar days, not business days, in order to determine whether there are responsive records, and also just generally to respond to a request, you know, whether that be the disclosure of the requested documents, or just a response to say, we're on it, we're working, you know, as expeditiously as possible to get you these documents. Once the determination has been made that there are responsive records, the agency must promptly notify the requester when the records will be available. So in unusual circumstances, the city or the local agency can request or can avail of the right to an extension of a maximum of 14 additional days. Unusual circumstances in the situation means, you know, if there's if the requester is asked for you know, a voluminous amount of documents, or if, you know, the city has to take, or the commission has to take some time to locate certain documents because it's not readily accessible. You know, generally speaking, there's broad discretion when an agency determines that extra time is needed, and usually all they need is just some sort of written notice to say, you know, because we have to spend extra time tracking down so many documents, we will need an additional 14 days. And the public agency has met its obligation under the Public Records Act if it's unable to identify the requested information after making a reasonable effort to work with the requester to clarify what information is needed and to help identify the records being sought. The act is satisfied once the records are made available, of course, and if the agency determines that an exemption exists. Also, if the agency, if certain records are already publicly available and publicly accessible, if it provides an index of its records and provides the opportunity for a requester to come in and search those records, then the agency has also satisfied its obligation. So exemptions under the Act. There are several exemptions under the California Public Records Act. They're generally based on competing interests, as mentioned before, such as privacy rights versus the public's right to know. And a public agency may release documents even if they fall within an exemption. You know, it's an exemption. It doesn't mean that the city must avoid disclosure, but the agency has discretion if an exemption applies. But if public interest outweighs the interest in keeping the documents confidential, the city may wish to disclose them. These are the broad categories of exemptions. Again, these are numerous under the Act, but just to give you a general idea of what that includes: preliminary drafts, notes, memos, only if they're not retained in the ordinary course of business, or if the public interest in withholding clearly outweighs the public interest in disclosure. So oftentimes, public agencies, for example, for environmental documents, environmental review documents, a public agency may be reluctant to disclose preliminary drafts because the agency or the staff needs to feel free in order to properly make important policy decisions without public input. Of course, once final documents are completed, once environmental reports are completed, those must be made available to the public. If there's pending litigation, however, once litigation is complete, those records are subject to disclosure. Any personnel records, if disclosure would constitute an unwarranted invasion of personal privacy, please note that things like salaries of public personnel are considered public information, and certain police records may also be exempt. Okay, and that's it for our presentation on the Public Records Act. Again, if for whatever reason a Public Records Act request comes your way, please send it to Director Segura as soon as possible, and then we will work with Director Segura and with staff to respond to such a request. And that concludes our training sessions for today.
Thank you so
Maybe-
much to the Office of the City Attorney. I think our next item are the findings to continue the teleconferencing of meetings pursuant to Assembly Bill 361. I think that's also you, Lindsay. Or perhaps it's City Attorney Steve Martin.
No, that's fine. Sorry, I was just muted. Yes, so, as we discussed, so now the commission will have an opportunity to take, its first action in order to, to adopt the findings that appear on, I think, agenda item 5. In order to continue to meet remotely. I believe our next scheduled meeting is July 19th. In order to continue to meet remotely at that time, the commission must make these findings as prescribed under AB 361. And so, someone must move to adopt, and then a vote must be made.
Right. Could that be me this time? As an executive director, or should we ask a commissioner?
A commissioner,
I
yeah,
would,
will have to do it.
Okay.
if I
Um,
could recommend also, Director Segura, that for handling this, we would need a motion from one of the members of the commission. We would need a second from one of the members of the commission on this for making these findings so that we could continue to telecommute for these meetings.
make
for
a
the next
motion.
meeting.
Yeah.
And then when we have a second, and so I would recommend that we take a roll call, and perhaps Rebecca, you have the roll in front of you and you could go through the list of names and ask for an aye or nay from each member just to signify their agreement to it.
Yes.
Yeah, I'm sorry, I should have specified that when taking action on any issue under AB 361, so as long as we're teleconferencing, all votes and all actions must be made by roll call.
Okay, great. So it does sound like Commissioner Padilla will motion. So why don't we turn the floor over to Commissioner Padilla?
Well, I make the motion that we approve AB 361 to apply to CMO so that we can continue to meet remotely during the state of our public health epidemic of COVID. Do I have a second?
I second. This is Monica Mejia.
Thank you, Commissioner Mejia. Rebecca, can you call the roll for the vote?
Yes, thank you. Commissioner Badejo, Commissioner Director Jr.,
Aye.
Commissioner Duarte, absent. Commissioner Ferguson,
Aye.
Commissioner Fritzi Armenta,
Aye.
Commissioner Gutierrez,
Aye.
Commissioner Johnston,
Aye.
Commissioner Michael Martinez,
Aye.
Commissioner Medoff,
Aye.
Commissioner Monje,
Aye.
Commissioner Ortega Jr.,
Aye.
Commissioner Zelen.
Aye.
Okay.
I think we have,
Mhm.
I think we have a vote. Great. So,
Was that 10 commissioners?
I think, was that an aye from Commissioner Sanchez? I think we cut him off for a second. That is 1, 2, 3, 4, 5, 6, 7, 8, 9. That's 11 ayes, and Commissioner Padilla and Commissioner Mejia. That's, I think, 13 ayes.
And
Great. So the motion passes.
Great.
And so that's the end of business. I guess the next is announcements, Director Segura.
Yes, give me 1 second. All right. So I just wanted to announce that we will have our next meeting on July 19th. And then we have 2 meetings in August. One is a special meeting, as discussed here today, for only 15 minutes, but we do need quorum. We will be reaching out to you the way we did with this to remind you and put it on your calendar. And then the regular meeting in August is in August 23rd. We'd also like you to think of relevant speakers on equitable climate policy for the next fiscal year. So if you have ideas on topics and speakers that you'd like to invite to be part of our commission meetings, please feel free to bring those up at the next meeting. We will be taking nominations for president and 2 vice presidents at our next meeting as well. And we'll see you very shortly. I want to thank everybody for attending, but we'll see you very shortly for the Q&A sessions. So thank you all again. And with that,